So today the topic for our discussion is appeals under the Arbitration and Conciliation Act. Broadly, we will be discussing the scheme of the Act which provides for appeals under various provisions. And then we will go into the specifics of the nature of orders which are appealable and what is the scope of review which is available to a court when it is looking at various kinds of orders under the Arbitration and Conciliation Act. So before we start, just to give a background, all of you know that the core objective of the Arbitration and Conciliation Act is to enable speedy resolution of disputes, which means that the dispute resolution mechanism does not start from the civil court. It is instead relegated to the Arbitral Tribunal. And with the hope and objective that the Arbitral Tribunal will arrive at a conclusion at a faster pace as opposed to a civil court. But that said, it does not mean that the decision of the Arbitral Tribunal is final, whether it be an interim decision or whether it be a final decision, which is called an award. So the Act itself provides for recourse to the orders passed by the Arbitral Tribunal. And at the same time, it also provides for a recourse to orders passed by courts also under the Arbitration and Conciliation Act. And this is provided in two provisions under the Act. One is Section 37, which falls in Part 1, and then secondly, Section 50, which falls in Part 2. So here, before I go into sections 37 and 50, it's important to outline the fact that what these provisions provide for is what is called an appeal. And there is another form of remedy which is available under the Arbitration and Conciliation Act against a final award. And that remedy is called the remedy of setting aside. Now, this is a peculiar remedy which has been provided for under the Arbitration and Conciliation Act, and it is distinct from an appeal because the nature of review that is performed by a court in a challenge to an award is very different from what is performed in an appeal. And therefore, the legislature has distinctly used a terminology which is not otherwise prevalent, which is called setting aside. So in this discussion, we will not be focusing much on Section 34 and setting aside, except insofar as they are relevant for our discussions on Section 37. So now coming to Sections 37 and Section 50. When we look at Section 37, it outlines the various orders under which one can approach a court of law to challenge either a decision of a court or an order of an arbitral tribunal. Section 37 also specifically says that no appeal is maintainable from any other order, which is important because it means that if a party wants to have a recourse against any order which is not enumerated in Section 37, then essentially it is precluded from doing so by virtue of the mandate of Section 37. And this also ties in with the broader objective of the Arbitration and Conciliation Act, which can be found in Section 5. As all of you know, Section 5 categorically says that judicial intervention is permissible only under the provisions which are specified under the Arbitration and Conciliation Act. So unless the Act itself gives a right to a party to approach a court of law or any judicial forum for that matter, no party has an inherent right to approach a court of law insofar as arbitration is concerned. For instance, let's say that today, arbitral proceedings are going on, and then an application is filed for amendment of pleadings. The tribunal passes an order. A question may arise as to whether an aggrieved party can go to a court and question that order and challenge that order. The Act itself does not provide for any such specific remedy. So, in that light, in view of the provisions of Section 5 of the Act, the answer will be that that party will not have any remedy immediately. It's not that the remedy that the order cannot be challenged at any stage. Eventually, when the final award is passed, the party can challenge that aspect also, as far as amendment of pleadings is concerned. But the idea behind Section 5 is that it is not that at every stage a party should be allowed to knock at the doors of a court and then delay the arbitral proceedings. Because as I said, the whole purpose of the Act is to provide for speedy resolution of disputes. So Section 5, therefore, it is important to bear the scheme of the Act in mind, and Section 5 in particular, while we are looking at Section 37. Because as I said, Section 37 also says that except for the matters which are provided in 37, an appeal does not lie under any other provision of the Act. So to take another example, let's say that a party goes to the High Court in case of a domestic arbitration for appointment of an arbitrator, and the court passes an order appointing an arbitrator. In that situation, a question may arise as to whether that order is appealable. The answer will be no, because Section 37 does not provide for an appeal against an order which is passed under Section 11. Having said that, the recourse under Article 136 of the Constitution is always available to any party from an order of the High Court, because that is something that cannot be statutorily precluded by way of a stipulation in the Arbitration and Conciliation Act. So the normal rule, as I said, is that unless the mechanism of appeal against a given order is prescribed in Section 37, the party does not have the right to approach a court of law. So with that preface in mind, now let's see what are the nature of orders that can be appealed under Section 37. And broadly, there are 5 kinds of orders which are provided under Section 37 which can be appealed against. 3 out of these 5 are against orders of court, and the remaining 2 are against orders of arbitral tribunal. So what are these orders of court which are appealable? The first one is an order which is passed under Section 8, but there's only one kind of an order in the Section 8 which can be appealed against, which is an order refusing to refer parties to arbitration. So as all of you know, under Section 8, a Section 8 application can be filed by a party if any proceeding is filed in a court of law and the defendant or the respondent in those proceedings says that, look, the plaintiff or the petitioner cannot file these proceedings because there's an arbitration agreement. So refer the parties to arbitration, which is a Section 8 application. In that Section 8 application, if an order is passed by a court of law saying, no, there is prima facie no arbitration agreement and I am refusing to refer you to arbitration, in that situation, an appeal is maintainable under Section 37. However, let's take the other scenario. The court says that no, there is an arbitration agreement and then therefore I will refer you to arbitration. Section 37 says that kind of an order is not appealable. And this again ties in with the preliminary remark that I made regarding the object of the Arbitration Act, which is minimal judicial intervention. So in the second situation which I gave, once the court finds prima facie that there is an arbitration agreement and it refers the party to arbitration, then what the legislature says is, let the arbitral tribunal decide as to whether there is an arbitration agreement, and then ultimately those findings can be challenged under the available provisions of the Act. So there is no appeal against that order, an order which refers party. The appeal is only against an order which refuses to refer parties to arbitration. And another remark there is that this remedy also was in fact included by way of an amendment in 2015. So the Act, as it was originally brought into force in the year 1996, did not have this remedy of appeal against an order refusing to refer parties to arbitration under Section 8. Now coming to the second provision, the second remedy, the second mechanism of appeal insofar as orders of court are concerned, that is an order which is passed under Section 9. Now, as all of you know, Section 9 is a remedy which is for interim measures, and any court may pass an order either allowing or refusing interim measures. That order can be appealed against under Section 37. The third form of appeal is from an order passed under Section 34. So as I said, Section 34 is the recourse of setting aside an award which has been passed by the arbitrator. So now what happens is, if a party comes to court under Section 34, challenges the award, and it may either succeed or it may lose. Section 37 allows that party to appeal an order under Section 34, no matter what the outcome. So even if the 34 is allowed, that order is appealable. If it is rejected, even in that situation, that order is appealable. That's Section 34. So these are the 3 kinds of orders of courts which can be appealed under Section 37. Now coming to the 2 orders under Section 37 which can be appealed, which are passed by an arbitral tribunal. First is an order under Section 16 which accepts the challenge to jurisdiction. So here again, the interesting thing to note is that let's assume a Section 16 application is filed before the arbitral tribunal and the tribunal rejects the application and says that no, I have jurisdiction. In that case, the legislature has not provided for any appeal. This again ties in with the objective of minimal judicial intervention prescribed in Section 5 and in the overall scheme of the Act. So then in that case, if the tribunal says I have jurisdiction, then the party will have to wait for the final award till it can challenge that finding on jurisdiction. However, if the tribunal says in a Section 16 application that I don't have jurisdiction, in that event, Section 37 provides for an appeal. And the answer is obvious, because if the tribunal says that it has no jurisdiction, then the whole arbitral proceedings have to come to an end and the tribunal cannot proceed any further, in which case the party should have a recourse, and that recourse is provided for in Section 37. And the last form of appeal which can be filed under Section 37 is an appeal against an order passed by an arbitral tribunal under Section 17, which is akin to an order under Section 9. So just as in case of a Section 9, An order allowing or rejecting interim reliefs can be appealed against. Similarly, an order under Section 17 passed by an arbitral tribunal can also be appealed against. So these are the 5 kinds of orders, and I reiterate, the only 5 orders that one can appeal against under Section 37. And the point of minimal judicial intervention, and which I reiterated earlier, has been noted by Justice Nariman in one of his judgments in Chintel's India, where he says that Section 37 incorporates within itself what is called the effect doctrine, and it analyzes 2 provisions in that regard. One is Section 8 and Section 16. As I said, only 2 kinds of orders passed under Sections 8 and 16 can be appealed against under Section 37, and not the other kinds, where either there is a refusal to refer the parties to arbitration under Section 8, or if the tribunal under Section 16 says that the matter is that it does not have jurisdiction. And the other kind, where the court under 8 refuses to, the court under 8 refers the party to arbitration, or under Section 16 if the tribunal says that it has jurisdiction, those matters can't be appealed against because of the effect doctrine. The effect is to continue the arbitral proceedings in those situations, and therefore the matter is left within the domain of the arbitrator, and the courts are not permitted to interfere at that stage. They may interfere at a later stage when the final award is passed, but not at that immediate stage. So that is insofar as the nature of orders which can be appealed against. Now, the more important and the more interesting issue, so to say, is to analyze what is the scope of review in appeals under Section 37. So here we have to go by the various kinds of orders which are appealable, because in my opinion, there is no one standard of review that can be applied for appeals under all kinds of orders under Section 37. So for instance, let's say an appeal is being filed against an order under Section 17, where the arbitral tribunal has either allowed my request for interim measure or it has rejected the request for interim measure. What should be the scope of review? There are various possible answers. Either the court in a Section 37 appeal can conduct a de novo inquiry and consider it as a first appeal, which means that it examines everything from the word go and examines everything afresh. That's one option. The second scenario is that it can apply the same principles which are applied in case of an appeal from an order of a civil court passed under Order 39, Rules 1 and 2, which is the famous Wanda versus Antox principle, which says that if the lower court or the lower forum has taken a plausible view, then the appellate court, in exercise of its appellate powers, should not intervene. And then the third possible solution is that the scope of review should be the same in a challenge to a Section 17 order as it is in a challenge to a Section 34, to a final award, which is in the Section 34 proceedings. So now, earlier, this position of law was not that well discussed and not well settled. But in the last 4 to 5 years, various decisions of the Delhi High Court and the Bombay High Court have now pretty much settled the position of law as far as the scope of review is concerned. And they have held that it certainly can't be a fresh inquiry into what the arbitral tribunal has held in its Section 17 order. And the courts have held that the Wanda versus Antox principle must be applied. And as long as the finding of the arbitral tribunal in a Section 17 order is a plausible one, then the Section 37 court in that situation should not interfere. So there are a series of decisions, for instance, of the Bombay High Court, which have held this. One is in Swan Energy, and then there's a recent one in Max Healthcare versus Touch Healthcare, which have all laid down this principle of law. And that again goes to the principle of giving primacy to the decision of the arbitrator and minimal judicial intervention, because as long as the view is found to be plausible, then the courts will not necessarily interfere in that decision. That is the scope of review as far as an appeal against a Section 17 order is concerned. Now, what should be the position where an appeal is considered against a Section 34 order? There, as I alluded to in the beginning, the grounds for challenge to a final award under Section 34 are very limited, and it certainly is not an appeal. So the court in a Section 34 proceedings is not permitted to consider the matter afresh. The grounds are based on either violations of principles of natural justice or public policy. So as far as the 37 challenge to a 34 order is concerned, that also now it is settled that it should be the same. The inquiry under a Section 37 decision should be the same as in a Section 34 decision, which means that the court needs to examine that whether the lower court, when deciding the challenge under Section 34, has accurately applied the principles of 34, or whether it has stepped beyond that. If it finds that it has not applied the principles of Section 34 correctly, And if it has carried out an analysis which is beyond the scope of review, which is permissible under Section 34, then it has the right to set aside the decision of the Section 34 court. But in the event that it finds that the Section 34 court has correctly analyzed the award in view of the principles laid down in the provision, then the award either has to be upheld based on that analysis or it has to be set aside. What the Section 37 court cannot do when it is considering an appeal against Section 34 decision is to modify the award. And that also stems from the fact that under Section 34 also, the court does not have the power to modify the award. So it goes back to the same principle that the nature of power of a Section 37 court is akin to what is provided in a Section 34 proceeding. Though on that power of modification, I must point out that this issue of whether the court in a Section 34 proceeding has the power to modify is now currently it's been referred to a larger bench by the Supreme Court. So the position of law may change in that regard. Now, another kind of order which I mentioned, which can be challenged under Section 37, is an order under is an appeal against an order under Section 16, which is an order passed by an arbitral tribunal. So let's say that the tribunal says that I have no jurisdiction and it therefore terminates the arbitral proceeding. The party that loses then decides to challenge in a Section 37 proceeding. So what should be the scope of review in that situation? Should it be the same as in a Section 34 proceeding or should it be different? As far as the situation stands today, let us take a scenario where a challenge on jurisdiction is raised in a Section 34 proceeding, where jurisdiction was originally upheld and therefore no challenge could have lied under Section 37 and party has come under Section 34. The law as it stands today in India is that irrespective of whether the issue is of jurisdiction or whether it is of merits, the scope of inquiry has to be the same, which is laid down in Section 34. There is no distinction carved out for jurisdiction analysis and a merits-based analysis. So the question is whether that same test should apply in a Section 37 proceeding also. In my opinion, the test under Section 37, when a court is considering a challenge to a Section 16 decision, should be slightly different. And I think that it should be what is called a de novo inquiry, which means that it should consider the matter as if it were a first appeal. And it can go into all the facts and examine the position of law as well afresh. And what is the reason for this? The reason for this is that when a party is entering into an arbitration agreement and it chooses and the two parties choose to go to arbitration, in effect, what they are doing is that they are excluding the jurisdiction of civil courts, which, as all of you know, is an inherent part of the right to access to justice. So when they are entering into an arbitration agreement and refusing to go to the civil court to have their disputes adjudicated, it is an important it's a waiver of an important right that every party has. Therefore, if a tribunal has arrived at a conclusion on jurisdiction either way, either accepting the plea of lack of jurisdiction or rejecting the plea, the court should conduct that inquiry de novo to determine whether that exclusion of civil court's jurisdiction and whether the choice of parties to go to arbitration is correct or not, is valid or not. The court should arrive at a decision on that based on an analysis as if it was considering the matter afresh, because that goes to the fundamental issue of the right to approach a civil court. And it can't be the error in the award or the error in the finding on jurisdiction cannot be justified saying that the award is in consonance of the principles of public policy. So therefore, that is one area where, in my opinion, the scope of inquiry under Section 37 in respect of a challenge against a Section 16 order can be slightly different when compared with the scope of inquiry which is conducted in other challenges, which is in an order against a Section 34 decision or a Section 17 decision. So this is one situation where the inquiry can be different. Now let's take another situation, which is in Section 37. The first situation which I mentioned, which is of an appeal against an order under Section 8. A party goes to court, files a suit. The other party comes and says that there's an arbitration agreement and files a Section 8 application. The court refuses to refer the party to arbitration. As per Section 37, as I mentioned earlier, that order is appealable. So what should be the nature of inquiry in that appeal under Section 37? Should it be de novo? Should it be limited as in the other cases? Or should it be something else? In this situation as well, bearing in mind the pro-arbitration approach which has been guiding the interpretation of the provisions of the Act as far as the Supreme Court is concerned, in my opinion, there as well, the inquiry should be de novo to assess if prima facie an arbitration agreement is found to exist. Because as you all know, the nature of inquiry in Section 8 is only prima facie. A court is not required to arrive at a final finding as to whether an arbitration agreement exists. Therefore, under Section 37, if in an appeal against an order under Section 8, a court finds that prima facie an arbitration agreement exists, then it should refer the matter to arbitration. And that should be based on a de novo inquiry and not an inquiry which is based on the test applied in other cases. So this is as far as the scope of review is concerned. Now, another interesting issue which arises as far as the Section 37 appeal is concerned is in the context of international commercial arbitration. So after the amendment in 2015, the ground of patent illegality, which was previously available in case of all awards passed in India for arbitration seated in India, that ground was done away with insofar as international commercial arbitrations were concerned. So that ground of patent illegality is now available only in case of a domestic arbitration. And this we find by virtue of the insertion in Section 34, subsection 2, capital A, which says that in other arbitrations other than international commercial arbitration, the ground of patent illegality is also available. So this is as far as 34 is concerned, and the challenge to a final award is concerned. The question is that what if there is an international commercial arbitration seated in India, and that tribunal, the tribunal in that arbitration, passes a Section 17 order? Can the test of patent illegality be used to attack that order of the arbitral tribunal passed in an international commercial arbitration when that order is challenged in a Section 37 appeal? Because Section 34(2)(a), which limits the applicability of the patent illegality ground only to domestic arbitrations, there is no similar provision in Section 37. So arguably the bar of patent illegality not being available as a ground under 37 is not there. But the question is whether that bar can be statutorily read into Section 37 when the court is considering an order or an appeal against an international commercial arbitration order. The issue, to the best of my knowledge, is yet to be decided. But in my opinion, if that same bar applies in case of a final award, and if the test for review of an interim order is pretty much the same as the test for review against the final award, then there is no reason why the same bar on patent illegality being available, or rather not being available, in international commercial arbitrations in case of Section 34 challenge, that should apply to a Section 37 challenge as well. So let's hope that sometime soon this question comes before a court of law and it is decided. Now, another issue that comes is that what happens in a situation where there is an order passed under the regime of the Arbitration and Conciliation Act, but there is no recourse against that order under Section 37. The example of amendment of pleadings which I gave earlier, saying an order is passed by a tribunal on amendment of pleadings and that order is not appealable. The question may rise as to whether a writ petition can be filed against such an order. Because as all of you know, every high court under the scheme of our constitution has supervisory jurisdiction over every tribunal which is subordinate to it and every court which is subordinate to it. An arbitral tribunal which is seated in, let's say, in Bombay, it is obviously subordinate to the High Court of Bombay. So the question is whether in that situation, the aggrieved party in that arbitral proceedings has the right to file a writ petition under Article 227 of the Constitution, challenging that order of the arbitral tribunal. The answer to this has been given by a 7-judge bench decision of the Supreme Court in SBP versus Patel Engineering, where the court has said that no, the remedy of a writ jurisdiction under Article 227 cannot be available as a matter of right insofar as orders of arbitral tribunal are concerned. And now, most recently, there is another decision of the Supreme Court which has clarified the test, and it has said that unless the order of the arbitral tribunal it indicates an inherent lack of patent jurisdiction, only in that situation that order can be challenged in a writ petition under Article 227. So for all other kind of orders, the remedy of a 227 challenge before the High Court cannot lie. And this, again, the reasoning behind this is founded in Section 5 of the Arbitration and Conciliation Act, which goes to the principle of minimal judicial intervention. Naturally, Section 5 cannot exclude the applicability of Article 227 altogether, because that is a part of the basic structure of the Constitution. So what has been done by the Supreme Court is to minimize the nature of cases in which a 227 writ can lie against an order of an arbitral tribunal. So that is insofar as Part 1 is concerned. Now coming to Part 2 of the Act. Part 2, as all of you know, concerns cases where the seat of arbitration is outside India. Part 1 concerns cases where seat of arbitration is within India. So just as in case of Section 37, the equivalent in Part 2 is Section 50, which provides the nature of orders which are appealable. And there are two kinds of orders which Section 50 recognizes as appealable. One is an order which refuses to enforce a foreign award, and two, an order which refuses to refer parties to arbitration under Section 45. So this you will find the second category which I mentioned is similar to the one under Section 37. Under Section 37, it is only an order refusing to refer parties to arbitration under Section 8 which can be appealed against. Similarly, under Section 50, it is only an order refusing to refer parties to arbitration under Section 45 which can be appealed against. In other words, if an application is filed under Section 45 before the court of law, saying please refer me to arbitration and please refer the dispute rather to arbitration, and that application is allowed and the parties are referred to arbitration, there is no right to appeal against that order under Section 50 of the Act. And in the other category as well, an appeal is maintainable under Section 50 only if the court has refused to enforce the foreign award, and not if it has allowed the enforcement of the foreign award. So this again goes back to the principle of minimal judicial intervention, which is enshrined in Section 5 of the Act. Here I must point out that Section 5, a literal reading of Section 5 indicates that it is applicable only to Part 1. However, our Supreme Court has held in Chatterjee Petrochem that Section 5 also applies to cases under Part 2 of the Act. So it is not that the principle of minimal judicial intervention is limited to Part 1. It also applies to Part 2 of the Act. Now, there are some other issues which arise insofar as appeals are concerned, which are issues such as of limitation. And this is especially in the context of the Commercial Courts Act having come into existence in 2015. Because invariably you will find that most arbitral matters will comprise a commercial dispute within the meaning of Commercial Courts Act. And the Commercial Courts Act in Section 13 provides a different regime for appeals. So one of the questions which is arisen is that what is the limitation period which is available for a challenge to an order under Section 37, whether it is a limitation period under the article under the Limitation Act or whether it is that prescribed in the Commercial Courts Act. So insofar as this is concerned, the Supreme Court has now held that if it's a commercial dispute, then the limitation period prescribed in the Commercial Courts Act, which is 60 days, will be the one which will be applicable. And in those limited situations where it is not a commercial dispute or where the value is less than 3 lakhs, which is the applicable threshold for the Commercial Courts Act to be applicable, in that situation, the Supreme Court has held that the period of limitation will be as prescribed in Articles 116 or 117 of the Limitation Act, depending on the forum from which the order is being appealed against. So it's either 30 days or it's 90 days. The court has also held that if there is a delay in filing the appeal under Section 37, then that delay can be condoned, because there was an earlier decision of the Supreme Court which had held that the period of limitation for filing an appeal under Section 37 against an order under Section 34 is the same as the period of limitation under Section 34. But now this position of law has been overturned by the Supreme Court in the decision in state of Maharashtra versus Borse Brothers, where the court has held that it is the period of limitation prescribed in the Limitation Act or in the Commercial Courts Act which applies, and not the period of limitation under Section 34 of the Act. So this is insofar as the limitation period is concerned for filing an appeal under Section 34. So as I said, the broad scheme of the Act is to minimize intervention, and therefore only certain orders can be appealed against. Whatever is not mentioned in Section 37 cannot be appealed against. Whatever is not mentioned in Section 50 in the context of Part 2 cannot be appealed against. Just to take another example, in the context of Part 2, Section 50, as I said, prescribes only one kind of orders to be appealable, which is an order refusing enforcement or an order refusing to refer parties to arbitration under 45. An argument was made in a matter saying that even if the appeal is not maintainable under Section 50, it can be filed under the letters patent act. But that argument has also been negatived by the Supreme Court, saying that the Arbitration and Conciliation Act is a special act, and therefore if that act proscribes filing an appeal against the given kind of order, then there can't be a backdoor entry by way of the letters patent act. So this, in short, is the scheme of appeals under the Arbitration and Conciliation Act.
Is there a participant is asking what is the interlink between the Evidence Act and the Arbitration Act?
Yes, the Arbitration Act specifically says that the tribunal is not bound by the principles of the Indian Evidence Act. However, having said that, courts have held that the principles of Evidence Act will nonetheless apply. And for example, in the context of, let's say, marking of documents, there is a decision of the Bombay High Court which has held that even though the Evidence Act does not apply, if the principles for marking of documents are not followed, then the award may be set aside on that ground itself. So even though, in short, even though the Evidence Act is not binding on the Arbitral Tribunal, the tribunal is supposed to follow the principles of Evidence Act.
The next question is, can you cite important case laws on today's subject?
Yes. So as I mentioned, one of the decisions on minimal judicial intervention is Raju versus Raju of 2000. It's 2004 SCC 539, which sets out the scheme of the act in the context of Section 5. Another one which I alluded to earlier is Justice Nariman's decision in Chintel's India, which is 2021 4 SCC 602. That also says that the effect doctrine has been incorporated in Section 37 of the Arbitration Act. And however, it says that Section 5 itself cannot be used as a tool to restrict the interpretation of Section 37. So in that case, what had happened was, the question was whether an order under Section 34, which refuses to condone the delay in filing an application for setting aside the award, whether that order can be challenged under Section 37. So the court held that yes, that order itself amounts to refusing to set aside the award, and therefore it is amenable to challenge under Section 37. And the court held that Section 5 itself cannot be used to restrict the kind of appeals which can be filed under Section 37.
Okay, sir.
I want to ask, sir, if the arbitral award is final under Section 35, then how that order is appealable? Because of both parties are, the arbitral award is final and both parties are their consent to that order. Now, both are, if there is a consent, how it is appealable?
No, if it is a consent award, if the award has been passed with the consent of both parties,
Yes, sir.
then it can't be challenged.
So in most cases, which orders are appealable?
The orders which are appealable are those which are mentioned in Section 37. Apart
Only.
from those orders, yes, only those orders. Apart from those orders, no other order is appealable.
So there's one more question. Can a clause that the arbitration award will not be appealable be included in the main clause?
First of all, there is no appeal against an arbitral award. It is only the recourse of setting aside, as I said earlier. And if the agreement says that the arbitral award shall not be appealable, or the arbitral award shall not be subject to challenge, in my opinion, such a clause would not be binding on the parties, because the remedy under Section 34, which is of a challenge to an arbitral award, it's a statutory remedy, and the parties cannot exclude that remedy by way of a contractual stipulation.
What is the time frame of appeals? In general, how long does it take for the appeal to get settled or the arbitration award to be set aside in the courts?
That is a very subjective time frame where no one can give any estimate or a range. It depends from court to court, and with the pressure that we have on our courts, it's difficult to estimate.
The next question is there any provision for interim measures when appealing against an arbitral award?
There is, as I said again, there is no appeal against an arbitral award. When there is a challenge pending against an award under Section 34, then there is no question of an interim measure. The interim measure is in respect of the, so for example, if a party against whom a claim has been passed of, say, rupees 100, it goes to challenge the award. Then it may be asked to deposit the money that has been awarded, which is 100 rupees, as a condition for its challenge being considered. So that is the interim measure that can be granted by the court.
Okay,
That's rather
so
a
there's a
condition
party.
for the challenge. Yes, sorry. Yes, so that is a condition for challenge.
Okay.
Sir, there is a confusion. I have some confusion between 34 and 37. What is the difference between
Yes.
setting aside and appeal?
Yes. See, setting aside is a terminology which is used specifically in the context of arbitral awards, because the idea is that a challenge under 34, it's not an appeal. It's not an appeal, meaning that the court cannot go into every single issue and find every single error of law and set aside the award on that ground. The grounds for challenge are based more on natural justice and on public policy, as opposed to the merits of the matter. The court can't look into the merits of the dispute when it is considering a challenge to an award under Section 34. And that is why it is not called an appeal. It is called setting aside. Whereas in case of an appeal, typically, as we know in an appeal under the CPC, in a first appeal, for instance, the
Mhm.
court can examine the matter as if it was considering it afresh. It can go
Okay.
into every issue, it can go into the merits of the matter.
That
That is
means we
something
can-
that is not available under Section 34.
Okay. So we can re-agitate all the grounds in 37.
No, so in a
Okay.
37, as I mentioned, it depends on the nature of the appeal.
Okay.
If the appeal is against an order under Section 17 or an order under Section 9, then you
Mhm.
can't re-agitate every single ground. The court in that situation also can't go into the merits and find and set aside the order on every single issue. As long as the court finds that the view taken by the court in Section 9 or the view taken by the Arbitral Tribunal in Section 17 was a plausible view, it will not set aside the order. So the notion of appeal in Section 37 is also not the same as a first appeal under the CPC.
Okay. So interim orders are under Section 9 and final orders is an award.
Interim orders before a court of law are in Section 9 and interim orders before a tribunal are under Section 17.
Thank you so much, sir, for such an illuminating talk. It was a great experience.
Thank you very much. And thank you to all the participants for attending.